Okay, we're now ready for the session on medical malpractice, insurance coverage, and tort reform. I will be substituting for Emerson Tiller for this session. We seem to have resolved some of our audio problems. I apologize for the problem we had during the first session, and hopefully we're in much better shape now. A couple quick announcements. There's some forms in the envelope that you picked up when you registered. One of those is an evaluation form, and we very much appreciate your feedback at the end of the conference. And also there's a CLE form, which you can complete and leave at the registration table at the end of the day. Our first speaker for this panel is Ronen Avraham. Ronen is one of the leading empiricists on these issues. He's developed a huge database for studying the impact of tort reform on the civil justice system. And he's going to speak to us today about the impact of tort reforms on medical malpractice settlement payments. Please welcome Ronen.
Thank you, Henry, and thanks for inviting me. And I wish what you told about me were true. This is a study, as the title suggests, about the impact of tort reforms on medical malpractice settlements. And okay. I guess this is a familiar picture, even if you haven't seen it before. What you see here is that over the last 25 years, every color here is a different tort reform. You know, tort reforms, I don't have to say it here, come in various flavors, even for a specific type of tort reform. There are many variations, but by and large, we can see that over the last 25 years, more and more states have enacted tort reform. And the question I'm interested in this research is, do they achieve their intended goal of reducing annual payouts? So that's the explicit goal of tort reform, to reduce annual payouts to the defendants. And I'm interested in whether this is indeed effective. I want to distinguish this from a much more important and interesting question which I cannot answer, and that is whether they are efficient, whether they do any good overall, whether they increase total welfare. I cannot answer this question, so I'm answering a much more modest question, whether they're effective, whether they achieve their intended goal. And the motivation for this is, well, I think it's important because many people think that tort reforms can cure the medical malpractice crisis, because if they do not, then even a rational basis test might determine them unconstitutional tort reform because they do not advance the legislative objective. Those of you familiar with the 2005 case in Wisconsin, they actually looked at those empirical studies, like the one that I'm going to show you, and found that there was a problem there with under rational basis scrutiny. So that's why the question of effectiveness is important. It's more as a constitutional matter. But if there is no crisis at all, as many other people argue, maybe it's exactly because tort reform works so well. And lastly, perhaps there are totally unintended and unanticipated consequences to tort reforms that we also might be interested in. Okay, so what's the kind of very quick theory behind this paper? Well, reforms could decrease total payments by reducing the number of cases, we saw it this morning, and by reducing the payments per case. So doing both will definitely work. Doing one but not the other will work, but there might be some offsetting effects, as we saw this morning. People talked about it. Reforms could also increase total payments by increasing the number of cases and or increasing the payment per case. This could happen, for example, there are many stories that could be told. One of them is that if there's tort reform, they dilute the incentives to take care, and we might see more negligence even if the damages are capped per case. So what I'm interested to see is which effect dominates. And the literature in the past has not reached a consensus on the impact of tort reform cases outcome. Some studies find certain reforms effective, while others found them to be not effective. And some studies failed to document any measurable effect of tort reform at all. Although I must say that caps on economic damages do surface out as effective. This also was Michelle Mello's conclusion in a recent paper she published about the impact of tort reform on medical malpractice, on awards. So what did I do in this data set, in this paper? I combined two data sets. One of them is a public data set, the National Practitioner Data Bank, which was established in the late 1980s, and is supposed to capture the entire universe of medical malpractice cases. Of course, it does not, for various reasons, which I will not go into now. It might come up in the Q&A. But it's still, no matter what you think about the quality of this data set, it's by far the largest and most comprehensive data set exists on medical malpractice payments, both settlements and trials. I'm looking only at settlements. And what I superimpose on this is a legal reform data set, which I got a grant from the NSF, and I created this data set, and it basically documents tort reforms in 50 states in the last 30 years, tracks legislation and strike-downs and upholdings. I don't know why I did it. It was a mistake. Shouldn't have done it. Too much work, but I did. And now it's publicly available. So I encourage you to use it, because at least part of the variation between the studies could be explained by the fact they just use different legal data sets that contradict each other. So hopefully we can reduce this variation. Statistical model is very straightforward. I have the dependent variable, which is number of cases per capita, and the average, three dependent variables, and the average settlement, and the total payments. And I run it on the reform variables, and I have a bunch of control variables, and have year dummies and state dummies, and later on time trend. We can talk about it. And what do I find? So the state level analysis, which is what many of the previous studies have done, they looked at the state level analysis, that is the average payment or average filings per state. What you see is that this is a reduced form of the paper, but what you see is that there's no effect. So you don't see any stars, it means no significant effect. Nothing seems to impact the average payment. And then when you look at the number of cases per doctors, then you can see that both caps on non-economic damages and joint and several liability significantly reduce the number of cases per doctors. And lastly, periodic payments also has an impact, but only in one of the models. It later on disappears when I had time trend. So caps and joint and several. And then when you look at a total payment, which is really what I think defendants care for, that although this does not include their defense costs, so it's not clear that this is what they really care for. But anyway, when you look at the total payments, caps on non-economic seems to reduce total payment by 20%, and it's not that robust, but this is what surfaces out from the state level analysis. What's unique about this data, so that kind of replicates what we knew about tort reform. It's only done in a relatively, or in a previously unexplored data set. So I'm able to replicate what we've known, but this data set enables me to do even more, and this is to, let me just summarize. So what are the effective reforms? Probably none. Only one reform potentially reduce the total payments per capita, and that's caps on non-economic damages. Do we have any counter-effective reforms that increase things? Well, no. And what about non-effective? The rest. So if you have to summarize the state-level regressions, it's previous literature's results are confirmed. I think it's boring. And however, the good news is that the NPDB allows for case-level analysis of the entire, presumably the entire universe of settlements. So let's see what happens when we do that. And here, when I just do the case-level analysis, so rather than summarizing, averaging out at a state level, I do a case-by-case analysis. I pretty much get the same results that I got in the state level. That is that tort reform has no impact on average payments. Of course, I cannot do case-level analysis of number of cases per capita, right? So the only thing that I'm adding now is to talk about the average payment. And it seems that nothing has changed. There is no impact to any of the tort reforms. However, and this is, I think, one of the major contributions of this paper, what I do here, which has not been done before, is to account for something that I think every lawyer knows, has known for years, and that is after a tort reform is enacted, within a very short time, plaintiff lawyers start to look for good cases to try and strike it down, get the reform struck down at the state Supreme Court of that state. So that creates expectations, right? And that can change lawyers' behavior. And what I can do at a case level, which I do not do at the state level, is to distinguish between cases that ended up settled after a reform struck down versus cases cases that occurred after the reform was enacted. That's why they're subject to the reform. But also, I can distinguish whether they were settled before the reform was struck down, in which case they were really subject to the reform, versus when they were settled after the reform was struck down, which means that when they were settled, they were no longer subject to the reform because the reform was held unconstitutional. So this is, I think, the contribution that I'm going to present here. And what you see is I think, a very significant impact that caps on non-economic damages, in fact, when they work, that is, when they apply, when people settle before the cap struck down, then they have a huge impact of 60–70% on the average payment, and so does the periodic payment reform. So what is going on? I have less than 1 minute. Clearly, caps on pain and suffering damages affect average settlement if you take into account the striking down. It's a question why they affect in the case level but not in the state level. I will get it in a second. And I want to suggest some kind of hypotheses for future research, one of which will be presented this afternoon. And the hypothesis is that lawyers delay high-value settlement until after reform is struck down. And if true, then caps have no influence on low-value claims, which settle in short time. And in fact, the impact that I'm observing is simply a selection effect, right? Low-level claims settle within the period of the tort reform. So it's not that tort reform has impact in reducing the average settlement, just they have the impact is through selection. Low-level claims settle soon, whereas high-level claims, severely injured people, the lawyers rationally tell them, look, let's wait, next year is pending now in the Supreme Court, let's hear, we can do much better. Of course, there are limitations to this behavior because of statute of repose and statute of limitation, but this is the argument. And I see Henry is moving anxiously, so I guess I will stop here. Thank you.
Thank you, Ronen. Our next speaker is Watanabe from the Kellogg School, who's going to talk about learning and bargaining in dispute resolution.
Thank you very much. Thank you very much for providing me this opportunity. So, the research question I'm investigating in this paper is pretty straightforward. I want to see what is the effect of tort reform on the time to resolve disputes, including settlement, and also the tried cases, and the legal costs incurred. And these things are strongly correlated because if it takes longer time, the legal costs will increase as well. And the payments from the side of the defendant to the plaintiff. And it's not just about the cases that went to the verdict, but also the ones, settled ones, and including the ones that are not just filed, but including the ones which are even at the stage settled before filing lawsuit. Okay, so that's coming from a very particular data set I use. So the question looks like similar to that of Avraham, but the Ronen, but the approach is pretty different. So usually many papers in this field are looking at like cross-state variations across state for the difference in tort reform. But what I do is, rather than doing that, I look at specifically, I will only looking at Florida, because in Florida there's a very nice data set about individual level cases, about 4,000 that I will talk about later, which is very much detailed, which has like a legal cost, how much was the cost for the defense side, and how long it takes to reach a settlement, or how long it takes to reach a verdict, and also what was the payment from the side of the defendant to the claim, to the plaintiff. Okay. So what I do is just looking at this Florida data and construct a game theoretic bargaining model, behavioral bargaining model, and estimate this model. And after estimating the parameter of this primitive parameter of this model, change the model parameter so that it's going to correspond to some hypothetical policy change, and simulate this estimated model to get a counterfactual policy simulation experiment. And that's the approach I take. So that's the very different part from the other papers. Okay. Okay. So the model is have this kind of structure. So a case starts. The case starts here. The side of the plaintiff contacts the side of the defendant, and we start talking. Okay? At any time we can file a lawsuit, at any time plaintiff side can file a lawsuit, it's a choice by the plaintiff. That's what I'm going to get as an outcome of the model. By solving the model, I get that. There's a statute of limitations, so before that, I can always file a lawsuit. And we can also reach a settlement without filing a lawsuit. If I file a lawsuit, we're in the litigation phase, and we can still bargain every period. We can still reach settlement every period until the date of the judgment by the court. Okay. So the model predicts these things. So if I give a parameter to the model predicts what will be the form of solution, whether the case will be settled without filing a lawsuit, or settled after filing a lawsuit, or whether it goes to the judgment by the court, and how long it takes to reach a settlement or to reach a judgment by the court, and how long it takes to file a lawsuit if a lawsuit has been filed, and what was the legal cost incurred, and then the amount of payment. Okay. And in this model, the trade-off is similar to Pearson-Klein, but a little bit more detailed structures here. The main trade-off determining the settlement timing is exactly what people were talking in the question before. The plaintiff and defendant have different beliefs about the expected judgment by the court. And as time goes on, the new information flows in. So we learn new information about the case through discovery or through knowing who the jury is, or through all these things, we learn more and more information. So there's a value of waiting. By waiting, I get more information. On the other hand, obviously waiting is more costly, because if I wait more, there'll be more and more things to do. Therefore, there's going to be increase in the legal cost. So the trade-off between the legal cost and the arrival of new information determines when to settle. And given that the legal cost and the settlement payment can be all given by the model. So with this model, I can prove that there is one-to-one correspondence between a parameter of the model to the outcome of these things. Okay? So the next thing I do is, because the Florida data have exactly these things in their data, so from data, because I can prove these are one-to-one correspondence, so from this data I can recover what is the primitive parameter of the model. So that's what I do in my estimation. Actually, the time is much shorter than I expected. So very, very quickly, I think I have until 10:40. Yeah. So here, just briefly, so the first one is the case is settled without filing lawsuit. The mean payment is about $300,000. And the ones settled after a lawsuit is actually, the mean payment is a little bit lower at $300,000. While the legal cost is very different. This includes the fee to the lawyer. It's about $9,000 for the ones settled without filing a lawsuit, but it's going to increase to $50,000 for the ones settled after filing a lawsuit. And these were the ones which went to the judgment. That's only about 12% of the case, and 75% of the cases are settled after filing a lawsuit, and only 12% of the cases are settled before filing a lawsuit. Okay, and obviously the judgment by the court is much higher than most of the settled cases. Okay. These are the statistics on timing. The first ones are the ones settled without lawsuit. This first, it spends about, these numbers are in quarters. It spends about 3 quarters before reaching settlement. And then the settlement cases settled after lawsuit takes about 10 quarters. Okay, so that is probably resulting in the difference in the legal cost. So these are the descriptive statistics of the data. These are timing, I will just skip those. And okay, so with this so because given these data, I can recover the primitive parameters in the model. Then after recovering the primitive parameters, I can simulate if this model fits the data well, and this is how it fits. So the lighter color is the data, and the darker color is the fit of the simulated model. So obviously, because I'm presenting, it's going to fit very well. So, okay. Well, it took 2 years for me to get this to work, but anyway. So let me go to the interesting part. So now, what I do is policy simulations. So before, I was estimating the distribution. For example, one thing I was estimating is the distribution of potential award for all of the cases. Okay? That's something I cannot observe because some cases settle, so I cannot observe what would be the potential award. But that's something I was estimating. So here, there are 3 potential hypothetical tort reforms, which is, some of these are not even feasible maybe. But I will just do it as a thought experiment. But the first one is a cap on jury award at $250,000. So what I do is before, I estimated this potential award, but now I cut this at $250,000. And what would going to happen with this thing, with this assumption? Then what's going to happen is expected time to resolution will decrease by about 15%. So the time it takes to reach settlement, or for all of the cases settled or going to the judgment, whatever, on average it's decreased by 14%, 15%. And the legal cost will decrease by 30%. And mainly this is because the time to resolution decreases a lot in after litigation stage, which let me show. So this is so these lighter colors is the baseline model and experiment is the simulation is the darker color. These are the quarters, and this is a fraction. The vertical axis is a fraction of the cases settling at that quarter. Okay? So before, more cases were settled later, but with this simulation, with caps on jury award, it pushes the settlement timing a little bit earlier. And that's in the after filing a lawsuit. So because those are the times, because in the model I allow the legal cost to differ before filing and after filing, and here there's a lot of decrease in timing, therefore the legal cost will decrease even more than the decrease in the timing. Can I go back? Yeah. And also the expected payment will decrease by 30%. It's natural because now we limit the potential award at $250,000. It cannot go above that. Therefore, the expected payment will decrease. Okay. I'd actually another 2, but let me just, maybe rather than talk about this, talking about why this happens is probably better. Why this happens? Why the settlement timing will be a little bit earlier? The reason is pretty simple because in my model, the trade-off is between the learning of new information and the legal cost per period, expected legal cost per period. If there's a cap on jury award, because this learning, the value of the news depends on what is at stake. If what's at stake is much lower because of the cap, then the value of learning will be much smaller compared to the legal cost. Therefore, it looks a bit more costly. The legal cost looks a bit more costly, therefore they will settle at earlier dates. So that is the mechanism why these pushing of timing, change in timing happens. So let me finish. If you're interested in other things, please read the paper. The limitation. So let me talk about the limitation of the paper. I think this is the most important part. The limitation is the following. Because here, I am assuming that the composition of the cases that are coming to the court is exactly the same before the tort reform and after the tort reform. So that's a big assumption I'm making because if it's less costly to go to the court, maybe doctors exercise less caution when they're practicing medicine. Therefore, there may be more cases that might be coming to the court, and that will change the composition of the cases coming to the court, and therefore, or coming to the court that people are going to dispute. Therefore, here, my results depend on that the case selection my result is conditional on case selection. Given that exact same cases are coming, this is what the result will be. But I think that's important. Still, it's important because if we don't know that part, we cannot answer what's going to happen if the composition changes. And another one is here, I don't look into the agency relationship between plaintiff and his or her attorney. So if the lawyer is not really working in the interest of the client, which I shouldn't say here probably, The result might change. That I'm working on that at the moment. Thank you.
Great. Thank you. Our next speaker is Max Schanzenbach, who was the moderator for the prior session. This morning he's going to talk about some of his work on the impact of tort reform on health insurance coverage.
So this is, first let me say this is joint work with my colleague at Northwestern, Ronen Avraham, and we're actually exploiting further his wonderful database on state-level tort reforms that extends all the way back to 1981. And we feel like it's the, well, since I'm an outside observer, maybe I should be the one to say it, I think it's the best state-level, the best database on state tort reforms done yet, and it's actually been now checked by at least one other person, and it's still evolving. But I think that's a tremendous achievement, and Ronen should get a lot of credit for it because it's going to improve the literature a great deal. Okay, so let me talk a little bit then about how we're using this data set and why we're actually looking at private health insurance coverage. Okay, so we're not looking at medical malpractice insurance. That has been studied a fair bit. We're actually looking at the effect of tort reform on private health insurance coverage rates. Okay, and the reason we're doing that is it's been hypothesized that if you have tort reform, caps on damages, right, limitations on punitive evidence, reforms to the joint and several liability rule, that this will actually lower medical costs. Okay, and there are actually a number of papers from the health economics literature that estimate elasticities, okay, of demand for private health insurance. So if private health insurance costs go up 10%, what happens to coverage rates? If they go down 5%, what happens to coverage rates? Okay, and our thought is we can actually use this literature and tort reform and a data set on private health insurance coverage rates by state to actually help us back out the price effect of tort reform on medical costs. Okay? And Ronen and I are going to argue that this is actually a pretty good measure of the social welfare effects of tort reform. Okay, so more on that in a minute. So that's an overview of the paper. Let me get to the nitty-gritty. Why do we study private health insurance coverage? Well, previous work, some of the work you've seen here, has explored the impact of tort reform on claims, on judgments, on settlements, on the, these find various things that reforms can increase or decrease or have no effect on all three of these variables. Ronen just pointed out a reason why these findings may be so non-robust. It may be because that there's strike downs and there's expectations incorporated into these things. We don't know. But the upshot is, so what, right? I mean, tort reform is supposed to reduce payouts, but payouts might be performing a valuable function. They might be giving doctors the incentives to take proper care, and if you reduce payouts, you may be actually hurting patients, okay? So we don't think that there's much in the way of social welfare that you can, there's few normative implications anyway, that you can really glean from those studies, okay? Why are higher average awards necessarily bad? Well, they're not if they're doing their intended job, okay? Okay, so but recently, those in favor of tort reform have linked health care coverage, private health insurance coverage, to medical malpractice reform. President Bush has said that we need to make health insurance available, and one of the ways to do that is medical liability reform. Okay? The Department of Health and Human Services has issued a study claiming that limiting that tort reform could reduce for non-economic damages, could reduce healthcare costs substantially by 10%, which would actually imply an increase in private insurance coverage rates of about 1 percentage point, which translates into roughly 3.5 million Americans getting insurance coverage. Okay, AHIP, we have a representative from AHIP here today, has also made this argument, saying that the current litigation system for compensating patients is expensive, slow, and does little to benefit patients. They also solicited a study arriving at similar conclusions to the Health and Human Services study, and here's an ad that AHIP has put out. Note the subtle nature of what they're suggesting. That they're clearly linking medical malpractice insurance to real costs borne by individuals. On the other hand, the Congressional Budget Office, which may or may not be a less biased source, said that medical malpractice costs are not a great percent of total healthcare costs. I believe this study, however, simply looked at the actual awards and administrative costs. They didn't look at things like defensive medicine, which is hard to estimate, and so forth. But they come up with a much more limited conclusion. Okay. We don't think either view should be rejected out of hand. Studies show, looking at individual types of practice like heart disease or cesarean section rates, have found that tort reform can reduce the costs associated with these. Okay? In addition, studies have found that medical malpractice insurance goes down after tort reform. Okay, and if the market's working, relatively competitively, we think that this will be translated into lower healthcare costs for consumers and higher rates of private health insurance coverage. Okay, a recent study also suggested, and this is just what I said, that in fact these costs do get passed on to consumers when doctors' malpractice insurance premiums rise. Medical costs go up to compensate. Okay, and as I mentioned before, studies are also consistently show that private insurance coverage rates are actually elastic, that they're responsive to price. Okay, and this is something we're going to exploit, different groups in the population have different sensitivities. Okay, so if you're a married, middle-aged person who's privately employed and has a relatively high income, you're almost 100% likely to have private health insurance coverage. Okay? But the young, the self-employed, and the unmarried are actually less likely to have health insurance coverage, and more importantly, they are more responsive to changes in price. So when plan price goes up, the self-employed are much more likely to drop their insurance coverage than those who are privately employed. Okay? And that's something that we can exploit to see whether the price effects behave among these sort of subgroups that should be more sensitive to prices in the way that we would predict, or that at least matches the model. Okay. Let me go through the theory really briefly, because we really do believe that tort reform could have offsetting effects in medical costs. Reforms could decrease premiums, and these are health insurance premiums I'm talking about, by reducing the provider's legal costs, by reducing defensive medicine, and as a very important paper by Bentley McLeod and Janet Curry has recently suggested, that actually tort reform, however, could increase offensive medicine. So it could increase unnecessary procedures like cesarean sections, okay, beyond what we would want doctors to actually be doing, because there's actually liability if you perform an unnecessary procedure and anything goes wrong. If the procedure was unnecessary, there might be liability associated with that. So there's defensive medicine, and people have now pointed out there's also offensive medicine, and tort law could affect the levels there too. Okay, reforms could increase health insurance premiums as well, right? So they could reduce the incentives to take proper precautions, right? This will lead to medical error. This will lead to greater medical costs, okay, to repair that error, right? You amputate the wrong leg, okay, now you have to go back and amputate the other one. You've doubled your costs, plus there's all the other costs associated now with being a double amputee, okay? It's a fairly straightforward issue, okay? And then, of course, there might be also increasing legal costs associated with this. So doctors might take less care. There may actually be potentially more litigation, right, even though the value of the litigation is lower, okay? So we use this current population March demographic survey, which is conducted by the US Census Department, which is a very large survey and has been conducted for almost 35 years. We look at 1982 to 2004 because that's when the CPS started actually collecting good data on insurance coverage. Okay, we look at the data covers different types of insurance coverage, so we know if people have Medicaid, we know if they're totally uninsured, we know if they have private insurance. We can't distinguish throughout the whole course of the data set, however, between those covered through their employers and those who are purchasing directly. You can really only do that starting in the mid-90s, well after most tort reforms are passed. Okay, so we can't make a distinction there. It's a limitation of the data. But the data set is large enough that you can get reasonable state-level averages and start comparing them across time and between states. Okay, and Ronen and I have already discussed his legal data set, so I'll skip that. I want to point out that we actually have a lot of variation across states, given our sample size. So 39 states changed their rules regarding non-economic damages. 10 were as a result of the state Supreme Court striking them down. So a lot of state-level studies, you only have changes going in one direction. Okay, here Ronen and I actually have changes going in both directions, that states adopt the reform and later they have to get rid of it because the state Supreme Court strikes it down. Okay, so we actually have a lot of variation, there's a lot of churning over this period, and we think that really helps us for estimating the impact. Okay, these are a bunch of controls that we throw in. What's really nice about these results is it doesn't really matter how much we control for. We control for prior insurance coverage status. We control for race, family income. all these other things. We can include them in the model or not, and we get very close to the same results. Okay. So let me actually talk about the results a little bit. I'm not going to show you the graphs if it's in the tables. They're in the paper, and we can talk about them in the question and answer if people have questions. But let me give you the upshot of the results. So the three groups we identify as most sensitive to insurance price changes are the self-employed, the young, and unmarried. This is from previous research in the health economics literature. Okay. The self-employed are actually very responsive. If there's a, I hope I get this right, if there's a 2 percentage points increase in health insurance prices, there's a 1 percentage point drop in coverage among the self-employed. Okay. So they're actually pretty responsive. Okay. And the studies that have been used to estimate this are actually really good because they look at changes in the tax code that really affected the coverage costs for the self-employed. Okay, so we're pretty confident that those studies are pretty accurate. The ones about the young and the unmarried are not as great because it's harder to get what we believe is really good variation in insurance prices for those folks, but they also are evidently much more responsive. Okay, the unmarried probably because they can't protect themselves through the spouse's coverage, whereas married couples frequently can. Okay. So what happens to these groups? And, these elasticities are 5 to 10 times greater than those estimated for the general population. Okay. So if we look at sort of middle-aged folks who are privately employed, their responsiveness is almost zero. Right. They only drop coverage when their employer drops coverage, and that isn't very common, although it does happen. It would be nice if we could figure out, if co-payments rise and these types of things, right? But we don't have enough. The CPS doesn't really allow us to do that. How am I for time? 2 minutes. Okay, great. So the marginal group findings summarized. Okay, so now we're measuring the effect of tort reform on these marginal groups relative to everyone else over a 20-year period by state. Okay. We find that, as a general matter, tort reform is positively and statistically significantly associated with increases in insurance coverage. The most robust results are for the self-employed. Okay. And we also get pretty robust results, which by robust I mean they survive sort of no matter what we try to do to them, no matter what model specification we choose. We get pretty robust results too for the young and unmarried, the single unmarried. Okay. The young and the married don't always work so great. They aren't always consistent across groups. But if we actually sort of take another group and say those who are single and young, which are actually, again, are more responsive even than the unmarried and the young by themselves, we get actually very similar effects to those that we estimate for the self-employed. Okay? And again, previous research has indicated these groups, the response of these groups are more price sensitive to changes in health insurance coverage. Okay? So what magnitudes are we talking about here? Okay. Basically, we allow each reform to have a different effect. Okay, so we enter the 8 reforms we look at separately. Okay, and we do that for a variety of reasons. One is that reforms to punitive damages. Well, punitive damages are quite rare, as we understand, in medical malpractice cases. Okay, and so you might think that punitive damages are relatively unimportant. And a lot of prior studies have actually grouped punitive damage reforms together or with other reforms when trying to estimate impacts. Okay. We actually have a large enough data set and a long enough time frame where we really don't have to do that. Basically, we find pretty weak effects from anything dealing with punitive damages, which actually we think is evidence that we're probably doing it right because we have a strong prior which suggests that caps on punitive damages or punitive evidence rule really shouldn't have a big impact because punitive damages don't come into play much in medical malpractice awards. Now, there's also selection issues, and folks have pointed out that this may be because cases that would have punitive damages are settling, and so you never observe them. But we can't get into that. Be it as it may, we don't get results for punitive damage reforms. The big reforms, it turns out, are collateral source, joint and several liability, periodic payment, caps on total damages, and weekly caps on non-economic damages. Okay. Caps on total damages tended to be the strongest. These groups exhibited the biggest response when caps on total damages were either passed or struck down by the state Supreme Courts. Okay. So if we sort of just assume an elasticity, which don't worry about it if you don't know what elasticity is, we can say that our results actually imply that individual reforms can reduce insurance premiums by about 1/4 to 1%. Okay, it's a pretty small effect, and some reforms pretty clearly don't have an effect, mainly the reforms on punitive damages. Okay. Conclusion. Okay, first of all, it's preliminary work. We forget about the second line. But we are fairly confident in our results, at least to the extent that the high elasticity groups, the groups we predict would be most responsive, are in fact those who respond. Okay. Now, what do we make of the fact that insurance coverage goes up? Okay. Well, you might care about insurance coverage in and of itself. We don't make much out of that because there's actually a debate in the economics literature that it's actually not clear if having insurance coverage really remarkably improves your health outcomes. Okay, it certainly protects your assets from seizure, protects you from bankruptcy, but it may not really improve your health outcomes. Okay, but there's still social welfare implications there. What we suggest actually is that, look, health insurance coverage rates increase. This means at least that tort reform doesn't increase medical costs, right? That if there's offsetting incentive effects, okay, they don't swamp the positive effects of tort reform. Now, I have to be a little cautious here because there's some things we can't observe, right? If you cap non-economic damages, now those are no longer internalized, okay? And if the quality of healthcare provided goes down, right, as a result of this, we may not be capturing this. So if in demand for health insurance is relatively insensitive to the quality of healthcare, which over a broad range it may well be, okay, then changes in the quality, like if quality was reduced because of reform, we may actually be misinterpreting these results as positive for social welfare. And Ronen and I are working on that more and talking about the implications of it, and it's something that I expect will come up in question and answer. So thank you very much.
Thank you very much, Max. You're probably getting the impression that having a good data set is pretty important to the research that the scholars accomplish. And the next speaker, David Hyman, has a great data set that he's been working with and producing a number of papers with interesting results. David's a professor at the University of Illinois College of Law.
Thank you, Henry. They asked me to go back to I don't know whether it's the old technology or the new technology to solve the reverberation problem. Okay, so I'm going to talk about one of a series of papers from using Texas data. We've got a paper out that looks at overall payments over a lengthy period of time. This paper looks at what happens to jury verdicts after the verdict. There's a paper on the impact of policy limits on all settled claims, and we're finishing up papers on defense costs and on modeling the effect of caps on non-economic damages. And the closed claims database is essentially collecting all claims that are resolved with a payment, irrespective of whether they're tried or not, although I'm going to focus here on cases that were tried all the way to a jury verdict. And it's important to use the more comprehensive source of that because it allows you to infer all sorts of things. And my focus, again, is awards versus actual payouts. You can see the title here. We call this the haircuts paper. Apologies in advance to the follically challenged among you for that. So why should we care about jury verdicts and what happens to them? Well, the first important reason that is not a great surprise to people in the room is jury verdicts are actually the way in which lots of people get what they know or think they know about the larger performance of the tort system. They're public, they're extraordinarily salient, especially when they get press coverage, which with bigger verdicts is quite common, and people use that to draw conclusions about the performance of the larger system. And the advantage of a closed claims database is it allows you to look more in depth at what happens to cases that don't get tried, but in this instance, because we have data on actual payouts, we can actually track what happens to each individual verdict. And you can sort of see some other reasons why verdicts matter. People's perceptions about the civil justice system are going to be influenced, and those perceptions affect their behavior. So lawyers advertise their big verdicts because they think plaintiffs care about them and choosing who to go obtain legal services from. The parties are thought to bargain in the shadow of the law in the formulation of a well-known article. They settle their cases, and most cases are settled in light of what they think will happen if they go to trial, and the information they have about what happens when they go to trial is, again, based on the verdict. People like me and others in the room who focus on the sort of instrumental aspects of the tort system, its ability to deter and compensate people, again, use verdicts to inform that. And obviously the sort of larger tort reform discussion and agenda, both in the general public and legislators, are going to be influenced by it. The difficulty is available information on verdicts and on what happens to verdicts is really quite misleading. If you look at coverage of this, both in newspapers and jury verdict reporters, you see large verdicts are systematically overrepresented. Verdicts for the defense are systematically underrepresented. And there isn't very good information about what happens to the verdict after it's issued, i.e., what are the actual payments. And practicing lawyers have long known that there are ways in which verdicts are adjusted. So what the jury thinks a case or a claim is worth is not necessarily what happens. So let me just sort of start with our findings. It's a long paper. There are a lot of findings. I've got now like 8 minutes, so I'll only focus on 4. The first point is that most verdicts receive a haircut. That is, the payout's less than the adjusted verdict. Adjusted verdict basically is what the jury thought the plaintiff was entitled to, plus prejudgment and post-judgment interest. The jury obviously doesn't compute those things, so that's why we use the word adjusted verdict. The second point is the bigger the verdict, the more likely and the larger the haircut that you observe. Third point is law professors like me, I teach civil procedure, tend to focus a lot of attention on judicial oversight, on remittitor, on new trials, on JNOV, and the tort reform debates tended to focus on caps. And those are the sort of 2 areas where people think most of what happens to verdicts after they're issued come from. We can actually, because of the way the data set is set up, figure out what explains particular parts of the haircut that we observe. And we discover the 2 things that everybody's been focusing on actually are responsible for a minority, about 1/3 of the total haircuts that we observe. And the last point, again, not hugely surprising to people who work in the field, but not widely appreciated in the public discussion, is policy limits, that is the malpractice policy of the defendant, are immensely important in explaining the amount that ultimately gets paid. Not irrespective of what the jury decides, but very, very significant. All right, so let me explain briefly our data set. We start with 14,000 closed claims, most of those involving payment. That's the way the database is set up. We focus on those with post-verdict payouts of more than $25,000. We get down very quickly from 14,000 to 360. Some of those are judge cases. Most are jury cases, but some of them are verdicts for the defense, which are followed by a payout. That's an interesting finding, but it doesn't help us in sorting out what we're interested, which is when the jury gives an award, a positive award, what happens to it. And what you see is we have 306 verdicts for the plaintiff, and our first finding, again, is 75% of them, or 228. The actual payment is less than the verdict, okay? Haircuts are very likely. Second point, the larger the verdict, the larger the haircut. On the x-axis, we've got the log of the adjusted verdict. On the y-axis, we've got the log of the payout, and I provided in the blue things for you what the actual numbers are. So if you have a verdict of $100,000, the actual payout is $96,000, or about a 4% haircut. If, on the other hand, it's $1 million verdict, the payout's $580,000. There's a 42% haircut. $10 million verdict, 66% haircut, $3.4 million. So you do get more money with bigger verdicts. Okay, the absolute amount of money goes up, but the percentage of the verdict that you're not getting goes up as well. Next, on the horizontal axis, I've got the percent of the adjusted verdict that's paid. The y-axis is the percentage of cases, and what I've done is I've separately broken out cases with less than $100,000 in verdict. okay? And you see a big spike at about 100%. That means a very high percentage of those cases are being paid at full value. If you then look at the next slice of the data between 100,000 and 500,000, what you see is that the spike at 100% goes down and the distribution starts moving to the left. What is that telling you? It's telling you, first of all, you're starting to pick up haircuts. They're more common because the distribution has moved to the left, and they're bigger because a lot of it is, again, to the left, okay? What happens between 500,000 and 2.5 million flattens out even more and moves even further to the left. And then finally, verdicts in excess of $2.5 million. The distribution has basically started over here and then ended up over here. And just to show you the cool things that PowerPoint is capable of, I put all four of them together. And you see what happens to the distribution as the verdict gets larger. I've only got, do I get another minute? I'll do it. I'll do it in exchange for another minute.
Do it in the Q&A.
All right, I'll do it again. Okay. Applause for the slide. There we go. All right, now if you look at an aggregate level at total dollars that was awarded versus payout, what you see is that we've got about $482 million. I should mention everything's inflation adjusted and expressed in 1988 dollars. If you want to get to present value, multiply by about 1.7. So of that $482 million, only $212 million gets paid. $270 million that the jury and the tort system thought that the plaintiff was entitled to just disappeared during the course of post-verdict determinations. And if you look at sort of what explains that, basically what you see is that judicial oversight and statutory caps explain about a third of the total dollars, the $270 million I just mentioned. The overwhelming majority is other factors, specifically settlement. Okay, and now let me just show you what I said is the fourth point, that is the significance of policy limits. Now, policy limits only matter with verdicts that are above those limits, right? Below those limits, you should have full coverage. So what we've done is we've separately plotted payout, the ratio of payout to limits, and we've separately plotted above limits cases, those are the ones in blue, versus below limits cases. So what you see, again, is a very impressive spike for the above limits cases at 100%. That is, payout is more or less equal to policy limits. In fact, almost just over 30% of the cases with above limits verdicts, irrespective of how far they are above the limits, end up being resolved at the limits. And more than half of the distribution is resolved at or below those limits. Now, obviously, half is above those limits as well, and the paper talks a little bit about that point. It turns out most of the above limits money comes out of the pockets of the insurance companies, not out of the pockets of the individual named defendants. So a couple of discussion points. How much time do I have?
2 minutes.
2 minutes, perfect. So we actually observe in this data set that policy limits appear to provide a de facto cap on recovery. And remember, individuals choose their policy limits when they decide how much insurance coverage to buy, although there are constraints on that. Individual hospitals may require a particular level of coverage, or insurance companies, but nonetheless, what's interesting is this is sort of a homemade or self-help cap, a de facto cap on recovery. And that raises some interesting questions that we're looking at in subsequent research, including the interaction of the policy limits cap with statutory caps. Stated differently, if you think you need a statutory cap because you're going off of verdict awards, irrespective of whether the idea is a good idea or a bad idea, if you think we have a problem because you're looking at awards, and it turns out a lot of the award money is not being paid, a significant chunk of the bang that you expect to get from the statutory cap may end up not being realized. Why? Because the money that was awarded that you think you need to cap was already capped by something else, that is the policy limits. We see again what Tom Baker has referred to as the blood money dynamic. Most of the money that's paid above limits is paid by insurers, not by the insured. There's considerable reluctance of plaintiffs' attorneys to go after personal assets We can talk in the Q&A on why that might be. And there's sort of obvious questions about how much coverage should people buy, how are people sorting themselves into the level of coverage they buy. Another issue to consider is a lot of attention gets paid to blockbuster verdicts, the big dollar verdicts, the runaway verdicts. But remember, our findings are the bigger the verdict, the larger and more likely the haircut, with policy limits likely to be the level at which there's payment. So if insurers are worried about the variance of payouts rather than the variance of verdicts, you wouldn't expect blockbuster verdicts to have much of an effect. It's going to depend not on what the verdict was, but on whether and how much it was paid. So my last slide is it's important to recognize that insurers are sort of rationally going to bargain in the shadow of payout rather than in the shadow of what the jury might happen to do in any given case. And we've got this reference to Willie Sutton, that there are two banks, one of which involves statutory caps and judicial oversight. There's money in that bank, but there's a lot more money in the bank next door. And with that, let me stop. Thank you very much.
Mic back. Could you, Jason, could you check that mic to see if it's working there, please?
This one?
Yeah. Okay. Our first commentator on these papers is Jason Snyder, who's a healthcare law and economics fellow here at the law school.
Hi, thank you once again for inviting me to give a discussion. What I'm going to do is talk briefly about each of these papers. I want to just recap the main findings as I see them, and trying to put each of these papers within the context of the larger literature on tort reform and these types of things that are in the empirical law and economics literature. Finally, since this is academia, I don't want to let anyone's self-esteem get too high, so I'm going to talk about some problems that I see with each of these papers. So first I'm going to talk a little bit about Professor Watanabe's paper. What he finds is that he develops this rather complicated theoretical model of litigation and settlement, and then he estimates it using data from Florida. He finds that his model, like he said, fits the data fairly well. The first question that I think that we should really be asking him is, why doesn't your paper look a lot like these other papers that have been done, where you look at some change in policy and how that correlates with some change in behavior? And I think the answer to this is that what he's really doing is developing this theoretical model, which you can use for something very specific, which is that when you have this knowledge of the underlying structure, you can actually infer what policies would happen, what the impact of certain policies would be without ever actually having a policy experiment in the real world. This is what I'd call the real killer application of this thing that he does, which is generally classified as structural econometrics. So the big example of this is he's able to say what could happen when losers have to pay all of the fees for litigation, even though we don't ever actually observe great experiments of this in the real world. And this is a very, very powerful approach. However, the big area for concern with this is that contrary to, or apart from most of the other studies, he has to make a lot of assumptions to get to this. And the assumptions are a lot stronger than most of these other studies that we see. And one of the big problems you might see is that he has a model that fits the data well, but there could also be a lot of other models that fit this data well that produce different conclusions. So this is one of these things where he's getting a lot out of this, but he has to pay a high price. Moving on to Ronen Avraham's paper, where he finds that caps in pain and suffering reduce the number and the size of payments, looking at a national database of medical malpractice suits. I think that that's his major finding, and I really would like to highlight once again what I think the key contribution is that Ronen's really developed and built this wonderful data set on state-level tort reforms. Before this data set existed, everything was basically a hodgepodge. Where it came from was kind of a mystery, and you just never knew. So when you'd read these previous papers written in the mid-90s, you'd go, wow, that's interesting. But this data set, this paper says one thing about the tort reforms, this one says another. So he is able to get a really detailed data set here that seems very valid, and then he's also able to show in his paper how this actually matters. He says, well, when you look at it and you include the information on the strike downs, for example, this changes the results dramatically. To my mind, this is the major contribution of the paper, and what it also suggests is that as scientists, what we should go back and do is redo all of the previous studies that have been done and using his data. So going back to even the classic studies by people like Kessler and McClellan, who look at the impact of tort reform on outcomes and costs, this probably needs to be redone. And since I view this as such a foundational contribution, I'm not going to mention any problems that he has with this paper. Hyman, Black, Silver, and Sage, like you just saw, they show that in Texas, the aggregate haircuts is about 56% of the jury awards. What I really like about this paper, and what we don't see enough of, is that this paper has an excellent descriptive component, that they really go through and describe what's going on in the dynamics. Most papers tend to really try and fetishize, I guess, causal stories, and they eschew this part of doing very good descriptive work. So I really think that this is nice. I like seeing this done. And the paper also implies that there's this crucial missing piece from this tort reform debate, which is all about these haircuts, that they're massive, that they're showing, and that this is probably very important, and it has a lot of implications for the settlement dynamics and the level of precaution taken by providers of health care and manufacturers. I think that the one thing that's kind of frustrating about this paper is that, unfortunately, they have this high quality data, but it's very limited. It only comes from Texas, so that you really can't do some of the rich institutional studies that you would like to see. For instance, you might like to see how haircuts are changed by changes in the tort system, like a change in joint and several liability. But because you're only studying one state, it's really hard to do this. And what this means to me is that since we see this as so important, it'd be very, very nice if we could get a more comprehensive data set that covers all of these issues. Finally, moving on to Avraham and Schanzenbach, they show that the state-level tort reforms correlate with an increase in insurance coverage amongst those at risk for not being insured. I think this is a very important and clever paper. The cleverness I see is that they're able to back out the costs using these elasticity estimates, just looking at this issue of access. So they're able to say something about costs without actually observing them. And I think that's very, very, very interesting. I think the other important fact that they really highlight is that tort reform has a very heterogeneous impact on the population. Tort reform is probably not going to impact someone that's making $200,000 a year, whether they get insurance coverage or not. It's just not going to matter. But what it really matters for these at-risk groups, and I think that their paper really highlights that tort reform has significant distributional implications for society at large. I think that there's an area of concern with this paper and almost every other paper that deals with these issues of looking at state-level tort reforms and how they impact real-world economic behavior. And I think this is an issue of omitted variables bias. So let me explain what I mean by this. One story that's also consistent with the findings that they have is that a conservative legislator gets appointed to the state legislature. The Republicans win the state legislature. They decide, okay, we're going to reform the tort system. They also decide at the same time, we're going to cut Medicaid benefits. When the Republicans or the conservatives cut Medicaid benefits, this would induce an increase in demand for private insurance. Thus, you might think that the correlation between tort reform and this increased demand for private insurance could be spurious. I think that, unfortunately, like a lot of the things we do, there's probably not a really great way of solving this problem. I think that an awareness of this problem is incredibly important. Maybe one solution to solving this is really understanding the political economy of the tort reform process, understanding the motivations when these reforms get passed, what they get passed with. That might help a lot. But I think in general that this is just a thing to caution yourselves with when thinking about tort reform, when thinking about these studies, is that they're very good, they're very well done, but they're all very limited. So I would just say take something from them, but don't view any one study as being definitive, because no one study is ever definitive. And we're just trying to build up a body of knowledge. So that's about all.
Our next commentator is Stephanie Canwit, who's the special counsel for America's Health Insurance Plans, the people who produced the ad that Max showed us.
Oh, I knew I was going to get bored for that shark bite, no pun intended there. That wasn't my ad, but anyway, one of our ad agencies did it. You've got to admit, it got people's attention, right? Trial lawyers, sharks, not going to make John Edwards or people like that very happy. I wanted to commend the papers. I thought they were incredibly important. I was especially intrigued by Professors Avraham's and Schanzenbach's paper on the, as Jason just pointed out, the relationship between tort reform and cost and the public policy implications of some of that. This is not just an abstract debate, this is a real public policy debate, and I think even with a Democratic Congress out there, that people might be listening to some of our pleas in this area to reform what we believe is a completely dysfunctional tort system. One of the questions that gets asked of me is, why do health insurers and health plans care about this issue? Well, obviously we get sued both directly and indirectly when doctors get sued, and we pick up the tabs. Professor Hyman pointed out, well, most of this money on these lawsuits come out of insurance payments. When you hear that, don't think these insurance payments are divorced from you. They're your money, they're our money, all of us are insured, and all of us end up picking the tab up when they're huge medical malpractice settlements. Also, obviously, we have been lobbying very hard over the last 10 years and working hard to reform the system, because basically we believe it actually impedes efforts to meet the challenges of the nation's healthcare system. And it raises costs for everybody. I like to put those challenges in 3 very quick buckets here, and I think it's helpful to think about them in those terms. One is affordability. You all know what we're dealing with that. We're spending almost, according to CMS figures, $2 trillion on healthcare right now. Unbelievable. It's also related, number 2, the second bucket, to the access issue. What do you do about the uninsured Americans? So again, Professors Avraham and Schanzenbach's paper is important on that, talking about how tort reform can reduce costs by as much as 2% for some specific price-sensitive groups and the elasticity of demand. One other footnote to that, I think it's also important for us to remember, we're just talking here about the commercial marketplace. We're not talking about the 50% or so, depending on how you count it, of the rest of the healthcare marketplace, which is government programs, the Medicare, Medicaid, TRICARE, FEBA, Medicaid, you know, the whole litany of S-CHIP, which is now in Congress being debated, etc. And this goes to Jason's point about the heterogeneity of the system. The system needs to be reformed, and we're just talking about one small piece of it. Last but not least of my 3 buckets, access affordability is my favorite because it really goes to the bottom line here, which is quality. What are we getting for the tort system? Is it working? Is it not working? You're all familiar with the Institute of Medicine studies about the high numbers of medical errors. You're all familiar with the RAND studies on the underuse, overuse, and misuse of medical procedures. And also my personal favorite, which is the geographical variations in care. The Wenberg work, the Elliott Fisher work at Harvard. Why is it, in one sentence, that Medicare pays twice as much money in New York City for a typical beneficiary than it pays in Portland, Oregon? It is not because the Medicare bennies in New York City are sicker. In fact, they get less quality care than the beneficiaries get in Portland, Oregon. And it just absolutely makes no sense. We have to fix that whole issue. 2 final quick points. One of the points that Professor Avraham and Schanzenbach cited in one of their papers was an AHIP study, my clients at the health insurers, which was done by PricewaterhouseCoopers last year, that I thought was fascinating, on the factors fueling rising healthcare costs. And they talk about everything, technology, aging population, etc. But they found out that 10% of costs of medical services were attributed to the costs of litigation, medical malpractice litigation, but also defensive medicine. And we can't forget the defensive medicine part. Yes, less than 2% of the injured ever file medical malpractice suits. Yes, as Professor Hyman and everyone else had pointed out, most of them result in no payments to the plaintiffs. Fortunately or unfortunately, the figures I have are 57 to 70% of plaintiffs, even in suits that are brought, don't get any money on that. But there's still an enormous cost to the system in terms of the defensive medicine statistics. And for those of you who are interested, there's some studies by Harris Interactive and others on the number of physicians, and it's the majority, by the way, 74% and up, who report that for fear of malpractice, they refer patients to specialists more often, they perform invasive procedures, MRIs, etc., to confirm diagnosis. Incredible proliferation of defensive medicine out there, and we are paying for that. Last but not least, I want to make one further point, which is this. And that's the interorum effect of the tort system as it currently exists. I have only to point you very briefly to the ABMT, the autologous bone marrow debacle for breast cancer in the 1990s. It's been estimated that we as a society paid $3 billion for ABMT procedures on women with advanced breast cancer, whom we could not convince, and I say we because at the time I was working for Aetna, we could not convince to go into clinical trials to determine whether or not that was the proper procedure or not. They were basically, I believe, stampeded into getting this ABMT procedure, which turned out to be useless in many cases and actually fatal in about 5% of cases. We can't have a system, and when we were at Aetna, obviously it was more sensible to pay for the procedure, which ranged from about $150,000 to $200,000, than risk tort litigation, which all of the insurance companies were threatened with all over the country on a weekly, if not daily basis. So we all have to keep that in mind, that just because the case didn't go to court in the first place doesn't mean that the insurance companies, etc., didn't end up covering medically questionable and in some cases harmful procedures simply by fear of a dysfunctional tort system.
Thank you very much, Stephanie. Well, I think I'd like to give the presenters a chance to respond to the commentators before we throw it open for questions. Any reactions?
Just quickly, I think Jason's points are well taken. It would have been nice if there was more state closed claims databases. Florida is one that he has used. We've had discussions with Neil Vidmar, who has done past work on this. The problem with using it for studying verdicts is the Florida database, although it's quite comprehensive in lots of ways and actually includes some things Texas doesn't. It doesn't include verdict amounts. So the only way to get those is individualized search at particular county dockets. And that's, I should hire Ronen to do it because he's already shown a huge preference for doing this sort of work. The other point, yeah, okay. The other point is actually states have started to do these databases, and some states, in Illinois is a sort of wonderful example. Illinois has had a database for longer than Texas has, but none of it's publicly available. So every 5 years, the Division of Insurance issues a nice report on it, but you can't get access to it, even though it's a treasure trove for doing precisely those sorts of studies.
Any other comments?
Well, you want to comment on yours?
I don't want to come to mine.
Well, I just had a quick response really, but I think Jason raises, the common problem with all of these studies is what else was going on? Were these reforms really what we would call exogenous? I mean, were they random events or were they driven by something in the state? And we can look at a couple of things, which we did. One is, were there trends in insurance coverage rates prior to when these reforms were adopted? So were people gaining coverage, for example, before reforms were adopted? And we can say pretty conclusively, no, there was no trend like that. More troubling is the Medicaid example, and there's probably more out there than just Medicaid, which is there's something simultaneous, which we couldn't observe in a trend, right, that was passed with these reforms because it was a conservative legislature and they did other things. We have looked actually at whether Medicaid coverage was affected by reform, and we can say no. That might be a power issue. We do think there should be a actually, other scholars have found a pretty clear substitution between Medicaid coverage and private insurance coverage, and it's driven by price and qualifications for Medicaid. But very few of our sample are actually on Medicaid because we've limited to working adults, so we could back out the elasticities. So the Medicaid coverage rate's actually pretty low relative to the rest of the population. And we can also observe that the people moving, and we could rerun these regressions and get the exact same results if we just look for probability of no insurance coverage, right, which would sort of address the Medicaid issue. So we do know that it's people moving from an uninsured state to a privately insured state instead of from a Medicaid state of nature, I mean not state as in Illinois, to a private insurance coverage condition. So I don't know, I mean there's probably other things you can think of, but that is one thing that we actually have thought of, because there are options for people out there. It's more limited for people in our data set because if you're a working adult, it's actually not easy to qualify for Medicaid. And we don't include children, precisely because of our concerns about Medicaid. So point well taken.
Okay, questions?
I also want to respond to a comment brought by Jason and also by Stephanie. So for Jason, surprisingly, there is no nice or high correlation between Republican legislator and tort reform. So in fact, me and others have looked at that, and there's no nice correlation. With respect to defensive medicine, one of the questions, I'm talking about the paper with Max, one of the questions that people might ask is, okay, so there's 1, maybe 2 percentage point increase in coverage for the sensitive group, but where does it come from? And we don't really know, but we think it's probably a combination, not an evenly weighted combination, but a combination of saving in liability, or reduction in liability, but also defensive medicine. And we think that probably it's weighted towards defensive medicine much more than towards liability. So if we arrive in what we're finding, we think that probably the best explanation is reduction in defensive medicine.
David, do you have another comment? Questions? We got a bunch of hands up there. They're right behind.
The question's for David. If you looked at companies that self-insure, and is one of the implications of your study that might be a mistake, or in a sense choosing not to have a cap?
Okay, well, we looked at medical malpractice cases, and so we looked only at medical malpractice, and there's a whole separate slide about limitations that the 10 minutes didn't allow me to go through. We only look at one state, we only look at medical malpractice, and the closed claims database doesn't require, it has its own set of limitations. So, and that also interacts with a sort of larger legislative context. So for example, the University of Texas medical system is not required to report to the Texas Closed Claims Database, but there's a statutory cap that applies separately to public institutions like that. And we quite expressly say we don't know whether the results would be the same if you were dealing with someone who was incredibly solvent. You might go after personal assets for that. Although we don't see different results depending on type of defendant. So doctors look like hospitals, look like nursing homes for cases in our data set. But we don't know about the cases that are in our data set. And we very expressly in the paper say you shouldn't draw any conclusions about how products liability haircuts work because we don't know.
Saw some hands right there.
My name is Bob Baser. I could be described, I guess, by Ms. Canwit and her group as one of those sharks, although I would like to think differently. I have a bunch of questions and comments. My first comment is that I guess that there's some problem that needs to be fixed on the back of victims and not with any cost to insurance companies, HMOs, etc. Because that seems to be the only discussion here. Professor Watanabe, I'm sorry, in his example talked about that it would be better if cases settled early. Well, I can tell you, I would love for all of my cases to settle without filing a lawsuit. It's never happened. You could tell your industry that they can call me up if they want to settle. I'm available. Caps don't promote settlement at all. In a state where there's, such as California, where essentially the malpractice industry is dead, a $250,000 cap promotes a $100,000 settlement in an absolute clear liability, horrific damages case. Otherwise, the case has to be fought like all cases. I can tell you that most malpractice cases require at least $100,000 cash advanced, and often 2, 3, 4 times that before there's a discussion of settlement. Also, what we haven't heard is anything regarding the cost to society because of the inability of plaintiffs, of victims of medical negligence, who can't get lawyers because of caps. Let's see.
We need some questions here.
Yes.
I mean, look, can you go to a question so we can get a response?
Okay, my question to Ms. Canwood, I'll move on to a question. It follows all of that. How many lives have been saved by these so-called defensive medicine procedures?
I don't know the exact number of lives that have been saved. What I would say is that I think we're all on the same page, that we feel the system needs to be reformed in the interests of consumers. I think we're all going to start out with that very same goal. You're going to hear some discussion from Michelle Mello and some others this afternoon about tort reforms that aren't traditional reforms, like early offer settlement, healthcare courts, patient safety legislation, by the way, which we at AHIP have tremendously supported, which is how to get information out there on medical errors and how to create a deterrent effect, which the current system doesn't for all sorts of reasons that Professor Hyman and the rest have done research on.
I've been allowed one follow-up.
Go ahead.
Would there be any benefit by capping the profits of insurance companies and the compensation to insurance company executives, including stock options?
There's heavy-duty regulation on that right now, as you probably know, given the SEC and everyone else. That's not the problem. That's less than 1% of the issue here in terms of the amount of money at stake in tort reform. It's simply not the issue.
Okay, I'm Kathy Sharkey from Columbia. Max, I have two quick questions for you. I know, but Ronen has a separate paper, so the process is to direct them to you. So first, the first one is just, of course, you look at these 8 reforms separately, and it might be interesting to know the correlations between them. And for example, it also could be helpful. Jason was asking about a potential correlation between, Republican legislators and enactment of reforms, and I too have found that with caps, there actually is not this correlation. But I wonder if you found sort of systematic variation, so certain jurisdictions that enact all 8 versus jurisdictions that enact only 1 of the 8, and you might find interesting differences. That's the first. And just quickly, the second is, I'm of course intrigued by your result that caps on total damages in medical malpractice would have a strong effect, and caps on non-economic would have a weak effect. And I wonder what you are, if you had to speculate. So obviously that has enormous policy implications. Most states pass caps in medical malpractice on non-economic, a few states on total. And I'm just wondering if you guys have fleshed out sort of a story. Obviously in your data you're looking beyond just jury verdicts, sort of what would explain that and whether there are policy implications.
I think we just cite you. Which, the story, I guess starting with the last question, which I covered.
I would just be more cautious and remind ourselves and everybody else that we don't think we can strongly identify the impact of individual reforms. So we kind of, I feel much more comfortable talking about the impact of the joint, the joint impact of tort reform. It's much harder for the reason you mentioned that they enacted this multiple narrative that enacted together. It's much harder to identify the individual, although we did try, Max is highly sophisticated in doing this, as you probably know. So we did try to kind of isolate individual impacts, and I'm not sure we exactly see things eye in eye, but I just want to be more cautious about it, especially given the significant implications that might follow from it.
That's a fair point. But we've come up with a theoretical justification for all of our results, so that gets close. No. One thing I would note actually is that caps on total damage. So the reforms are highly correlated with each other. We're going to add a table about this soon, except for caps on total damages, which states tried first and they didn't fly because the state Supreme Courts by and large, and they switched to these other reforms. And what Kathy's sort of getting at is one issue with capping this particular damage category is that lawyers are smart people and they can start trying to get the same type of damages in through other rights. So non-economic damages are capped, but you can try to present, it's like real psychological harm, so we get a lot of that same evidence in which influences the jury's decision. So how much would it really matter? Punitive damages are capped, but then if they're not that common anyway, right, then they're not going to matter either. But we have to just because of the correlation that Ronen pointed out, we have to be pretty careful in making any firm conclusions. And we're trying to get, there's a couple tables at the end where we try to actually look in a very small window around when a reform was adopted to see if that, because that actually reduces multiple very problems a fair bit. Does that, and they match fairly well to what we report sort of the general regressions, but I don't feel comfortable saying I know collateral source rules what's doing the work here, or that even caps and total damages is what's doing the work here. So it's a frustrating aspect of the paper. But the people who are doing this work, I think, have to acknowledge reforms can have offsetting effects. Some reforms could be good, and this is the Bentley, McLeod, and Janet Curry point. Joint and settlement reform could be really good if it starts putting more liability on the people who are actually causing the damages, right? You get better incentive effects then. But caps on damages might have a really offsetting effect, right? Because now doctors are more careless, right? So but you're absolutely right to bring that up. We're going to deal with it more in the next draft.
Okay. I have David Hyman, and then Richard Anderson, and then John Day.
Yeah, just 2 quick points. Punitives are actually more common than people think in medical malpractice cases. Punitives are more common than people think in medical malpractice cases, particularly when the defendants are nursing homes. But even against physicians, you see them. But what you don't see, at least in Texas, where we can track it, is people collecting their punitive damage verdicts. Even though there's a statutory cap in Texas on punitive damages, which changed during our time period, payouts end up being lower than the capped amount. Okay, suggesting that the cap, may have mattered in setting the range of bargaining, but it certainly, with an above cap verdict, you'd expect if the cap was the thing that was driving it to get payment at the cap level. Second point is obviously lots of attention on non-economic damages, but you can have in medical malpractice cases huge economic damages in the form of medical bills as we get better at doing things to people and charging them for it over the lifetime of medical care. That can add up to very significant dollar amounts, even with $0 in non-economic damages.
Because you've got psychological evidence and psychiatric, right?
No, it's straight economic.
It's just straight economic.
Straight economic medical bills.
Oh, they're just investing more in getting economic damages.
It's just lifetime treatment for a bad baby is not going to be psychic. It's going to be medical expenses.
Rich Anderson, I have a couple of comments and questions to ask about the Texas study, which certainly is a very interesting study. First, I would make the observation that even though I think it is widely accepted that outlier verdicts often tend to get reduced, I don't think we should underestimate the effect on the system of those verdicts. If every time you walk into court, you have the perception that you're facing the financial equivalent of the death penalty, it will affect how often you are willing to put yourself in that arena. In looking at the Texas data, it's very interesting data, but you made an observation which I think is true, and then it leads me to ask a question. One is that virtually all excess of policy limits cases are the responsibility of the insurance companies rather than the responsibilities of the individual defendants. Therefore, it's not entirely clear to me why the gravitational pull of the limits should be so strong, because in fact there are no limits in those cases. However, to the extent that the limits are a gravitational pull, then I think there's a real problem in looking at Texas as exemplary for the rest of the country, because the prevailing limits in Texas are about $200,000 per doctor, where they're between $1 and $2 million per doctor in virtually the entire rest of the country. So gravitational pull. So I'm wondering if you accounted for the relatively low limits. And finally, with outlier cases, another question. With outlier cases, they're normally very adverse outcomes, which means that almost always on a practical basis, there are multiple defendants. So I wonder if using your database, you're able to account for the fact that an injury may have been compensated in total by multiple defendants, and that when you look at the individual outcomes, you're missing that additive effect.
Yeah, thanks, Rich. All excellent questions. On is Texas exemplary? I taught at the University of Texas for a semester, and they're just different. It's the Republic of Texas, as they prefer to remind people. But leaving that issue aside, well, actually, let me continue on that for a minute. We have across all paid claims measures of the the primary insurance policy, and what we actually see, now these are paid claims, this is not necessarily the universe of all physicians, but in paid claims, median's about $500,000. It's not 200,000. You do see coverage policies of 200,000 or less, which frankly surprised the heck out of us. And you see $1 million policies as well. The median level of coverage, though, is 500K. It's actually, I think, I'd be interested in talking to you about sharing data, because it's actually very difficult to get good information about how much coverage people are buying and how that's changing over time, and we're obviously quite interested in that. On perceptions and how they affect willingness to go into court, we actually discussed this briefly in the haircuts paper, and it's a sort of very preliminary, I almost hesitate to call it a finding, but in years after there are these blockbuster verdicts, we don't see any time trend at all over the entire data set. We also don't see it after big verdicts in increases in payouts across all claims or in the number of cases that are going to trial. And you would expect one or both of those effects to end up materializing. So it may well be happening, but we just can't see it in our data set. It would be helpful, I think, to do cross-state comparisons, and maybe with a big enough data set we could do that. In terms of the excessive and the assertion that there are no limits in those cases, Texas has, like most states, the sort of bad faith refusal to settle doctrine, which I guess is the basis for your observation. All I could say is they've got it, and lawyers tell us that they try and set it up, but people end up settling at or close to limits, notwithstanding that dynamic.
Well, it's not just the bad faith, which is a separate issue and an important one, very important in a state like Florida, but it's the common law notion that if the defendant makes the demand of the insurance company, that the insurance company settle within policy limits, even if that's made with a wink and a nod, as it often is, that the insurance company is then responsible for any verdict in excess of policy limits, and that's way more than an 80-20.
Well, Texas has that doctrine as a result of the Texas Supreme Court opinion called Stowers, and notwithstanding that, we see, that probably explains why, when there are payments above limits, they are overwhelmingly from insurers rather than from named defendants. But it doesn't explain the sort of gravitational forces, I think you nicely put it, of policy limits. Finally, on multiple defendants, our payment data is from all defendants. Okay, so all payments are included here. So the haircuts that we're observing are based on all of the payments that are received. Now, when we do the study of the effect of policy limits, we can only do that for a subset of the data because of the way that the reporting in the closed claims database works. But we're pretty confident we've got all payments from all sources derived.
Thank you very much, David. Last question/comment from John Vale.
It's actually going to be a question.
Max, I know you want us to ask Ronen questions too. So Ronen, if you would work on replicating the proof of Fermat's last theorem while I ask this question to Max, and then you can report on that. But Max, you've given us a soundbite here that tort reform gives a 2% decrease in premiums to certain. Like it or not, you're going to see that in public debate soon. So this question about effects, that leads to a 2% essentially premium subsidy, say. Do you know the magnitude of the numbers? In other words, is it, if you save $100 million in tort reform, does that 2% look like $90 million, or does it look like $9 million, or does it look like $1 million? If we believe the 2% number, which you probably have to adopt the whole package, and then maybe that's what you got. But if you believe that number, it's 2% of healthcare costs.
standard error there. That's, you
That
know,
was the end of the range. I just want to remind everyone. It was from 0.5 to 2%.
yeah. I mean, we can't get, we don't confidently pin down a number, right? But you can play with the numbers and try to back out what the real cost savings would be for the medical system. Okay, but that's still contingent on believing that we're capturing, that if there are costs to tort reform, that we're capturing them by looking at the medical system. And there's costs to tort reform that might be outside of the medical. Like, if you killed a guy, that's not going to cost the health insurance companies more, right? And so we wouldn't capture that by looking at medical costs, right? And so if you wanted to, if your organization wants to attack the paper, I think that's the route you should take, that there are costs outside. No, I'm giving this to you. That there are costs outside the medical system, potentially significant ones, and our analysis may not fully reflect that, right? So
and what I'm getting at is the distributional effect, because you know that whatever costs are there are being taken from medical malpractice victims and redistributed somewhere around the system, and we don't really know where.
well, it's that these distributional issues don't keep me awake at night. I mean, they're being distributed to people who are buying health insurance, and so it's, you know, I mean, why distribute for people from the 150 million people who want to buy health insurance to people who are fortunate enough to get an attorney and then work their way through the management court system to get an award. That doesn't concern me, frankly.
Please join me in thanking the panelists for this great session.